Hey everybody, welcome back to Counsel, a Hirschler video series focused on legal and business trends keeping employers up at night in these challenging times. My name is Andy Sherrod, and I'm here again today virtually with my colleague Jaime Wisegarver. We're both members of Hirschler's employment law team, and we've been engaging in a 5-part series of short video discussions focused on some new and important changes to Virginia employment laws facing all sorts of businesses starting in July. Today's installment will focus on whistleblower protections. Jaime, take it away.
Sure, Andy, the new whistleblower protection laws protect employees who, in good faith, report suspected violations of federal or state laws to any supervisor or government official. It protects employees who participate in government investigations and proceedings. It protects employees who refuse to commit a criminal act or who refuse to comply with an order that would violate the law. In short, Andy, it's really broad in scope. It basically prohibits an employer from discharging, disciplining, penalizing, or retaliating against an employee because of that employee's protected conduct. The law provides for a civil action for an injunction. The employee can seek reinstatement to the same or an equivalent position with the company. The employee can seek compensation for lost wages, attorney's fees, costs. So there's a variety of remedies available. Andy, what do you think the practical impacts of this new law is going to be?
Wow, this new law seems really broad and a little vague. So, that's a combination that'll lead to litigation in my view. I think the idea that this covers reports to supervisors of any sort of violation of federal, state law, be it statute or regulation, what is a violation of the law can sometimes be in the eye of the beholder. And I think that there's certainly some possibility for misperception on the part of some employees about what may or may not be, normal business practice as opposed to a violation of the law. So I think that there's, certainly some chance for litigation on that front. Also, I think, this is, again, just yet another employee protection that an insubordinate employee, for example, could try to latch onto to shield him or herself from disciplinary action if they refuse a valid company directive. So yeah, I think this one's ripe for disputes going forwards, and employers are wise to really be careful and make sure that their policies are compliant. So I think my key takeaway here is to revisit your anti-retaliation policy, make sure that it covers all aspects of this new law, but even more importantly, make sure that you've got an effective reporting mechanism so that supervisors who receive reports of misconduct from their employees that they're supervising can convey those to upper management so that they can be properly addressed and so that the company knows that those complaints have been made when they might be considering disciplinary action against an employee for some other reason, so that it doesn't appear to be retaliatory. So yeah, lots to think about on this one.
Yeah, Andy, it seems like this new law is a little bit nebulous, but also yet another employee-friendly law, which is something that we discussed on one of our earlier segments of Couch Counsel. It seems that Virginia is headed in that direction. Thanks so much for your feedback, Andy. And to our listeners, thanks for listening. If you have any questions about this topic or suggestions for other topics that you'd like for us to cover in the future, please don't hesitate to contact us. Thank you and stay well.